On this morning's docket is case number 112081 in the matter of Mindy Lynn Miller.
May it please the court, Stan Haslett appearing for the Disciplinary Administrator's Office. We had a hearing on June 5th of 2014 in this matter. The respondent didn't appear at that hearing. The panel in that case addressed the issue of whether or not we had complied with Supreme Court Rule 215 regarding service and notice of hearing on the respondent, and found that we had. A final hearing report was filed on June 11th of 2014. The respondent is now represented by counsel John Ambrosio. Mr. Ambrosio entered his appearance in this case on July 30th of 2014. And on that same date, Mr. Ambrosio filed a pleading under Supreme Court Rule 212 indicating that the respondent did not take exceptions with the findings of fact made by the panel, but wanted to address the court regarding the appropriate discipline in this case. Briefly, the findings of the panel were that the respondent, while she was in-house counsel for a local entity who owned a number of nursing homes across the state, the panel found violations of competence, diligence, communication, and the general misconduct rule in connection with her representation of that entity in 5 separate cases. In fact, in 4 of those cases, default judgments were entered because of the failure of the respondent to respond to the lawsuits filed by other litigants. The panel also found that the respondent continued to practice law during a period of time when her law license had been administratively suspended because of failure to comply with CLE requirements and failure to pay attorney registration fees. And finally, the panel found that the respondent failed to cooperate during the investigation of the disciplinary complaint against her. The panel and our office both recommended indefinite suspension in this case. I think that's a justified recommendation due to the failure of the respondent to cooperate, the failure of the respondent to appear at the hearing, and the misconduct involved in this case. In addition, there is the uncertainty before this court as to exactly what happened, because the respondent didn't, at least from the respondent's perspective, because she didn't participate in the process either during the course of the investigation or at the hearing. Now, she will have the opportunity to, obviously, to address the court today and maybe enlighten the court as to some of the things that were going on in her life. It's my understanding from talking to Mr. Ambrosio that the respondent and Mr. Ambrosio really are not taking exception with the recommendation of indefinite suspension, that there are certain things which she will address to the court today that she recognizes that she needs to confront. This will give her time to do so. From our perspective, it ensures a reinstatement hearing, which I think is necessary to have so that the respondent can appear before 3 attorneys, her peers, and prove by clear and convincing evidence that she's fit to come back in the practice of law. Addressing emotional and physical issues that may exist in her life at this time, but she needs to prove to her peers and to this court that she is fit to come back into the practice of law. And frankly, I'm very happy that Mr. Ambrosio entered his appearance, and I'm very happy that she's here today, and very happy to learn that she's on the road to doing those things. But bottom line is that there needs to be a reinstatement hearing to make sure that the public is protected and that she has addressed those issues that are going on in her life. I'd be happy to answer any questions.
So do I understand that because she's hired an attorney and appears today, you're not upgrading your recommendation to disbarment?
I'm keeping it the same.
Right.
Yes. I would have, had she not appeared today and not appeared at the hearing, I might have another circumstance.
Well, I can't think of a situation where when nobody showed up at any point in the proceeding, you didn't come here and modify your recommendation. I'm just trying to make clear that that's the reason.
Yes, it is.
But that you're satisfied that with the minimum 3 years and the reinstatement hearing that the issues that are involved are covered. So I'm just circling around.
Yes, I am satisfied.
Do you have a position on what she would need to demonstrate to the panel for the reinstatement hearing? Are you? I know you're handicapped because
Right.
There was no answer to the complaint. There was no appearance by the respondent at the hearing. But are you aware of anything that we should be on the lookout for? The reason I say that is because you did not reserve any rebuttal time.
I did not. That's correct.
And if counsel and his client mentioned a number of different things to us, we're going to have to take them at their word, because there's no chance for you to say, I agree, or no, I don't. So this is your chance to tell me, are you aware of anything in particular that we should be looking for the reinstatement hearing conditions?
I brought up my main concern. I think there are emotional and physical health issues involved in this case. I think Mr. Ambrosio and Ms. Miller are going to address the court about those issues. I think that's the primary concern I would have, is she emotionally and physically fit to practice law? And that's what I think the panel should primarily, a reinstatement panel should primarily focus on those issues.
Okay. Are you aware of those specifics, or are you going to rely upon counsel and the respondent to tell us today what those are? I'm
not completely aware of the specifics. I've had conversations with Mr. Ambrosio. I believe, although I have not seen a report, that there are issues regarding depression in this case. It all fits logically to me from what I've seen in the past, that would be an explanation for why the respondent would not have appeared, why the respondent engaged in the misconduct she did. She basically just checked out. I mean, she didn't file answers to lawsuits, she didn't answer discovery, she didn't respond to motions. She apparently was working from home. This is all in the record. It just all fits in. I mean, I think when she represents to you, as I believe she will, and Mr. Ambrosio will, that she suffers from depression, that is, I believe that to be the case.
All right, thank you. Any more questions? Thank you, counsel.
Thank you.
John Ambrosio on behalf of the respondent. And any time my opponent would like rebuttal, even though he hasn't asked for it, I'd be okay with that, because I think this is very important when we look at where this young woman is going to be 3 or 4 years down the road. The panel recommended an indefinite suspension. We concur with that recommendation. This young woman is not ready to practice law, and she will tell you today she doesn't know when she will be ready to practice law. So what the indefinite suspension does, says in 3 years you can apply. Then you do your petition, then the disciplinary administrator's office does an investigation. You have a full reinstatement hearing wherein her therapist and medical personnel will testify as to what she was going on at this point, at the time of the hearing, at the time she was unable to answer the charges by the disciplinary administrator's office, the charges by her client, and the complaint. And is she capable at that point, 3 or 4 or 5 years down the road, to practice law again? And we can't tell you at this time that she's ready. We know at this time she's not ready, and we don't know when she will be ready. As I understand what happened in this case, and my client did describe it much better than I can, and the more I learn about depression, the less I understand it. It's hard for me to understand it. She started therapy sometime in June. She is going to a therapist on a weekly basis. She is selling her condominium in Topeka. She has moved back to Beloit. She is living with her parents, her mom and dad. She's an only child. She did not work and was unable to work for months. She is now working a part-time job. She is on medication. The medication is taking. She has started on the road to recovery. She's here today. She was not at the panel hearing. She could not answer the charges filed. She couldn't meet with an investigator. She's come a long way since that time, but the road to recovery will be long. She has indicated to me, and she will tell you today, she doesn't know when, if ever, she will be able to practice law again. She doesn't even know if she wants to. She may look for another career. The medication is starting to level her out. She will indicate to you there were periods of time where she does not recall what was going on in her life, what job she was assigned by the chief counsel or by the chief financial officer of the corporation. She doesn't remember the lawsuits that were filed that she was assigned to defend. She had a hard time dealing with day-to-day things. When I give my lectures, I always say, I don't understand depression. I've told you this before. People would say 20, 30 years ago when I represented a criminal defendant or somebody in depression, I don't get it. Get out of bed. Get out. She will tell you, I couldn't do it. I couldn't put one step in front of the other. She's working on that now. Mr. Chief Justice, I don't know what to put down, what the panel will have to look at when and if we have a hearing 4 or 5 years down the road, because we don't have the therapist report yet. The therapist is not ready to give us a report. The therapist is not ready to talk about what she is going to need in addition to the therapy on a weekly basis and the medication on a daily basis. They're taking this in steps. The way I heard about this is a law school classmate of mine picked up the phone and said, I'd like you to look at this. My niece is in trouble. She's back living with my family. Can you look at this? And we looked at this, and it was obvious when people don't answer the investigator's queries, when they don't answer the letter from the disciplinary administrator's office, it is one of two things. They have an impairment that is drug or alcohol related, or that individual is depressed. We talked. She indicated to me that she was on the road to recovery, but this was going to take a long, long time, if ever. We concur with the recommendation of the disciplinary administrator's office. The indefinite suspension means that there is hope at the end of the tunnel. A disbarment, although in this state you can still reapply after 5 years, hurts her in the job market, hurts her as she moves ahead in her therapy. I admire the fact that she was able to come here today, and she will now address you with your permission about her situation.
Counsel, before we get to that, on the issue of reinstatement conditions, sometimes we consider harm to the client or clients. I don't see any findings in the hearing report that would give us anything to hang our hat on with that. Do you agree with that?
I agree with that. I agree with that. And I do not know what harm to the client there was. I have no idea.
One of the reasons I was asking opposing counsel and you now for a little bit of specificity on what the panel should be looking for is because I don't want, let's say, a substance abuse counselor to come in and testify, I've checked her out, she's ready to go, when that is not the issue in this case. So that's all I'm looking for.
Okay, I understand.
Some specifics on what they'd be looking for.
Yeah, I understand. And we're going to have to let her therapist back then, when this happens, tell us what she needs to do. Then we're going to have to develop a program. And if she's able to practice law again, she's probably going to need a supervisor. Now, I will tell you, KLAP has assigned her a monitor, and they haven't met yet. KLAP is now involved in it, and Ms. McDonald has talked to my client. They're working on a monitoring agreement. She's going to be assigned a monitor so they can meet with her whenever they're required to meet her and to go through this process. And it's going to be a long process. And I've been up here before, and I tell you, my clients tell me, I'm not sure I'm ever going to practice law again, and I think my client is going to tell you that today too. But I understand where you're coming from. May I?
Please.
Thank you. May it please the court, my name is Mindy Miller, and thank you for your time today. First, I want to sincerely say that I have the utmost respect for the court, Mr. Hazlitt's office, and the rules of ethics. I find myself here today at a place where I never imagined I'd be personally or professionally. I'm not here to make excuses, but to be held accountable. I've always been someone who crossed the T's, dotted the I's. In retrospect, I found myself in a situation where I tried my very best, but my capabilities and my best wasn't adequate. It's hard for me to even comprehend that I've lost this time of my life. I sincerely don't remember most of it. I left Topeka, sought the support of my family, because I was honestly unable to care for myself. And by that, I mean I couldn't function day to day. It has been a daily struggle for me to even get out of bed I found myself unable to really tend to any facet of my life. Again, I'm not here to make excuses, just to share that I'm making every attempt to try to put back the pieces of my life and travel down a road to recovery. I am under the care of a personal physician for treatment of clinical depression. I attend weekly counseling, and I have been in contact, as Mr. Ambrosio said, with KLAP to begin a monitoring relationship. I know I have a very long road to travel. I'm hopeful that I can manage this condition and return to a productive lifestyle. I have no desire at this point to pursue a career in the legal profession, in the future even. But this is something I've worked very hard for, and I hope that you'll give me the opportunity to retain my license.
And you're okay with it? Yeah.
I am fine with the indefinite suspension.
All right, thank you. Do we have any questions for either counsel? I see none. Thank you both.
Thank you.
Thank you all for your arguments this morning and this afternoon. Court will take this matter under advisement